Let's talk mediation. Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote awareness of mediation in the world around us and to talk about mediation and other alternative dispute resolution solutions from the perspective of a common person. We continue with a short legal disclaimer. The views expressed herein are the personal perspectives of the speakers and may or may not represent the views of a larger professional community they belong to. The conversation series aims to provide a general overview and awareness of the subject matter involved and may not be construed as a professional or legal advice in any manner whatsoever. This session is being recorded for wide circulation. Let me introduce the main speaker and the guest panelists for today's session on the practice of mediation. We have Dr. Joanna Dupree as our lead speaker. Dr. Joanna is a professionally trained and skilled mediator and a family dispute resolution practitioner accredited with the Attorney General's Department. She has a graduate diploma in family dispute resolution practice, a master's degree in law, and a PhD in human rights and children's law, and holds the title of Doctor of Legal Science. In addition, she is a master practitioner of neuro-linguistic programming, a life coach, a researcher, an author, and a public speaker. She possesses multidisciplinary knowledge and an empathetic approach, allowing her to build rapport with any client regardless of their age, sex, or cultural and religious background. We welcome you, Dr. Pri. It's a pleasure to have you on board with us today.
It is an absolute honor to be here. Thank you.
As guest panelists, we have Dr. Indirani K.S., Principal in Charge, Bishop Cotton Women's Christian Law College, Bengaluru. Dr. Indirani is a law graduate from Andhra University and has completed her LLM in labor laws from Bangalore University. She also has a PhD on her attribution of human rights obligation to multinational corporations, a legal study to her credit from Andhra University. From various of her professional accolades includes MHRM in Human Resource Management, a diploma in Personnel Management and Industrial Relations. She has been a practicing advocate. As an academician, she has been involved in shaping the education process of students and training them in various facets of law. Her articles have been published in both national and international journals. She is joined today by Dr. Jyoti from her team, who is a professor of the college and will be adding valuable insights on the conversation. We welcome you on board, dear ladies, academicians. It's a pleasure to have you here. We also have on our guest panel today Ms. Kavita Balakrishnan. Kavita is an empaneled mediator with the Tamil Nadu Mediation Center, Madras High Court, Family Courts, District Courts, Chennai, and the Labour Courts. An active legal practitioner at Madras High Court, District Court, and Family Court, Chennai, in original side, appellate side, and constitutional jurisdiction, she has a vast experience of both advocacy and mediation and has also authored the book Laws Relating to Tamil Nadu Housing Board. We welcome you on board, Kavita. It's a pleasure to have you here with us.
Thank you.
So, Dr. Pri, you have been practicing mediation in Australia. We would love to know your experience. First of all, what mediation means from a generally common person's perspective. And you are a multidisciplinary, and we would love to know your experiences there in Australia. The floor is all yours.
Thank you. A mediation is an alternative dispute resolution process, which means that there's a discussion between the parties which is happening outside the court environment, in which a third neutral and not connected to the parties person is helping them reach an agreement. This person is not making decision for those parties, but encourage them and really guide them to achieve the good conversation about all the issues that are important for them. To clear the misunderstanding, to understand their own points of view, to be in their shoes, really to be able to reach understanding about the other person point of view.
Yes, so true. And as a practitioner, as a human resource person also, do you
Mhm.
feel this adds value to their dispute when it's resolved amicably between the people?
Oh, I think it is a very ancient way of resolving disputes. And whatever is old is tested 1,000 times through the centuries. And it was showing the excellent results in old times until the law practices were developed and were written in the law books, and has the power of people feeling, that they are not judged. The people don't want to feel to be judged, but as well they want a fair process. And legal process is legal, but doesn't mean it's fair. And people are feeling this. This gives them the opportunity really to say what they want, but as well to be the makers of their own agreement. In opposite to the court agreement, which is made by the judge, and the parties don't have their say. And there's always one party which is stronger in the preparation to the court proceeding than other. And some parties, they don't have enough money to have a legal representation, which already put them in a very not favorable for them position, and the process doesn't create a peaceful resolution. And mediation gives them all tools to do that, because they are going to be their own decision makers, not the judge.
Yes. And now we would love to hear from from Kavita, who is a practicing advocate. Kavita, as Dr. Pri also told, that power to the people of feeling not to be judged. Kavita, you have on your credit thousands of cases that you have mediated. So, from a common person's perspective, what has your experiences vis-a-vis litigation? If we want to know that.
Um, Basically, in India, the commoners are made to wait in court for years together, and they never get an opportunity to talk, either to their counsel sometimes or to the other side. So, when they get an opportunity here in mediation to talk to the other side, and the conducive environment is created by the mediator, it has become very easy for them to talk to each other and arrive at a settlement. That is the basic thing. And the satisfaction they get is that it's a much valuable than getting it judgment from court, which is imposed upon them. In court, they will get a judgment whether they like it or not. It is upon them. Only choice given to them is they can go for an appeal. Even in appeal, it is not guaranteed that they will get the way they want it. Sometimes people can create their own solutions. They can be very creative. So that gives them a greater pleasure and satisfaction than going to courts. But of course, certain things we need to approach the courts for establishing the legal rights, so that we cannot avoid it. But apart from those things, people can resolve other issues here amicably.
Yes, most definitely yes. And now we come to Dr. Indrani. Dr. Indrani, since you are doing a very good work of teaching the younger generation about mediation, and in fact you have been giving them an exposure of online of practice of mediation. You taking them for their internships with real in as a observers. So, what has your experience been? What is the reaction of the younger generation? What do they think about it?
Okay.
Thank you. In the first place, as an academician, you find the days when we studied law, we did not have this subject as such. Though mediation or the alternative dispute resolution is part of our life, our upbringing from the Indian scenario, it was only through legislations in the later time that they looked at it as a subject that needs to be looked into, especially in the area of teaching. It was only after 2002 when the ADRS system was, the act was brought in, and then they felt, the Bar Council felt that it should be one of the subjects to be added into our education line. Okay, when they added this, initially it was only that we used to read into the act as such, what is um, the alternative dispute resolution, how far we can use them. But the Legal Services Authority, they were the ones who actually looked into the prospect of looking into the NICA sections. And then they found out that post simulations have to be conducted in the college to see that the children are trained to understand this alternative dispute resolution. Number one, it is because of the conjunction that is happening in the civil courts, where there is no speedy trial. And second one is the human concept, the human relations that need to be understood. In India, especially those days, we had this concept of joint family system, which slowly over a period of time is coming down. And if you look into the education system of law also, we initially had LLB, which is a 3 year course, and then we had BA LLB, which is a 5 year integrated course. Now, in this BA LLB, we did study a little of political science, a little of sociology, a little of history and economics. So it actually gives an opening to the student as to what the society would be before they can apply the law onto them. But now the requirement of education has become open to such an extent, it's opened up that you have the integrated courses with other areas of education, like you have business management, you have BCom LLB, you have BSc LLB, you have engineering LLB, and now the new concept of bringing in even the medical LLB is coming in. So when you have so many areas of education, the concept of human relations or the society or sociological aspect is not looked into as much. And that is the reason this one particular clinical course 3, which is called the clinical course 2, which is called the alternative dispute resolution systems, has been introduced, where we do give them a little theoretical exam and then we have a simulation that is carried out. The simulation is on all 4 areas. That is, what is it? Arbitration, negotiation, conciliation, and finally mediation. Conciliation and negotiation and arbitration are looked into from various other acts as such, like you have the labor laws, you have other areas where a little of conciliation has been looked into. But when it comes to family and retaining the family values and issues, that is the place where mediation works. And that is one area where we as academicians look into molding of their future.
That's
So we carry, yeah.
Yes, please continue. Please continue.
So this is given as a simulation process where we teach them exactly where mediation can be made applicable. Number one. Second one is mediation is found in labor laws. It is found in what is a criminal law now, being brought in 498A, being brought in where adultery has become a ground for divorce. That is also brought in. So it is moving or broadening the aspect of mediation to be applied to the people. So first the students need to learn as to how they need to understand the society, how they need to understand the relationships. And for this, we do have a small stimulation in the college as such, and then we send them to the mediation center. We now being placed in Bangalore, and we have the Bangalore Mediation Center, where on rotation basis, we do send our students. Jyoti will tell you regarding how she trains those children in sending them to the internships.
Lovely. Lovely. Before we talk to Dr. Jyoti, we will here briefly talk to Dr. Pri. Dr. Pri, you are a master practitioner of neuro-linguistic programming and a life coach. And from this aspect, do you think that it is very important, or how has your experience in this aspect been with mediation? Because like Dr. Indrani is saying, that the human values need to be now inculcated into, children. That's the good work they are doing. They are, inculcating that value system that was lost somewhere, because disputes are inevitable in society. But then how we are going to handle those disputes, talk a lot about our society. Are we going to fight tooth and nail on small disputes, and go to the court, adjudicatory process, try to put each other, blaming each other, or we try to amicably resolve? As a society, it's for the whole society that we are taking the society to a higher level of education, which already was prevalent in our earlier times, but we lost it somewhere. So I really want to know about your this views on this as a practitioner, how your experience has been. Dr. G, you are on mute. You're
So,
not
I strongly believe that a very important part of mediation to be successful is education. The knowledge about mediation, although in Australian schools, law schools, this is an additional subject that the student can choose to study. Still, the knowledge about mediation is very low in communities. And I will tell you, some even mediation practitioners, they are making logos, they are looking more like they are having meditation practice than mediation. They are having beautiful lotus, flowers, or like, beautiful pictures of walking through the forest. And they are stopped even, and because they are having time to time logos on their cars, and they are asked whether they are going to provide meditation classes. That we have started with ourselves to ask where to coach ourselves to make the message about our practice very clear what we are doing, and educate communities about the mediation practice. What is that? What does do to them? What the tools this gives? And therefore, coaching, the mindset coaching, is coming as well from education about newest research. Like, for example, research which is showing that prolonged conflict is changing neurologically children, that changing their genetical blueprint forever. They need to really learn again how to communicate, how to understand, how to trust, because this part in their brains called hippocampus is shrinking because of that. And they cannot think logically, they cannot study effectively. The impact is massive. The impact is massive as well on the parents, because they are in constant distress, fighting with each other, who is right, who is going to have a child. They are using, tactics like alienate the child from another parent. But a child is a half of mom and half of dad. They don't want to be divided. They want to have them both. Then teaching how children are behaving, what is happening with the child when the parents are fighting, that the children to cope with the constant stress, they are choosing a parent simply to be able to survive. They survival mechanism is making them to choose and to tell other parent whatever they want to hear, because they will want to be loved by both of them. and therefore, I believe that education about as well confidentiality in mediation as a very heart, the very heart of mediation is as well important, because people are having, the belief that they are going to say something very important for them, and then especially in particular communities where there are much broader families, where the families are multi-generational, they're afraid that there's going to be said something what they don't want to be revealed. And in Australia, this is as well a very challenging, because we have the reporting obligation. If we are going to hear that there's a prolonged violence and abuse of a child, we have to report this. And I had a client from a Farsian group where they wanted to talk, but and they wanted to use mediation, but they doubt whether this is going to be passed to other members in their community, was greater than the need of resolving the issue. And they knew that I am going to report if I'm going to hear about child abuse or physical abuse of, within the family. And this is something what, closed the door for many people, the reporting process, which is as well important, because otherwise the children are, suffering. There's never-ending suffering. So this is a tool which allows other authorities to step in and do something. But general, what I wanted to say about coaching, the pre-mediation coaching and mindset coaching is preparing the parties in mediation to understand better their points of view, to be willing to hear the other person, really what is said, not only listen, because we can listen and, is going with one ear, is released through another one, but really to hear, to capture the sense of the other person, need of being listened, and what the person is saying, why the person is saying. To understand that this is not a battle, but we are in the peacemaking process. This is mediation. And this requires education. This requires endless talking about that. Gathering people and showing them how this is practically looking like. That people can as well, practice between each other. How this will be if I will be in the seat of a mediator, how this will feel, that I am going to be impartial, and ask them question why you want to be impartial, because we the mediators, we are the peacemakers. We are having the mission of changing other people's lives, and this is as well, beautiful mission, but as well as coming with a lot of suffering, of people suffering that we are taking into us. This requires as well, like mental hygiene from mediators to be at the top of their abilities to be able, to run the process. I believe that each and every person, that really, because we are some mediator, we cannot be impartial if we are going to work only with one person and prepare the person for mediation. We are losing impartiality in this moment. But when we are doing this for the whole group, and the group as well, includes those people, then it's completely different, because we are talking in general. But without preparation as such, I think many people, they cannot still grasp the importance of particular behavior, the listening, the being empathetic to this, what other person is saying. And of course, as well, explaining the stages of grief, that when at the very start, everyone is angry, to explain how we are acting in each of the stages and why this is important for as well the parents involved in such dispute to resolve this so quickly as possible. Because, for example, the newest study as well is showing that people who are in after separation and are in the prolonged dispute and conflict, they are losing their ability to be productive in their work, and their productivity is dropping dramatically, like 40%. And this requires a very long period of time, like around 6 years, to go back to this person that they were at the start. This creates a massive loss in those people's lives, and mediation as the restoration of their life, to give them life back to them. And I think this is a healing process.
Definitely. The way you said it, that it's a healing process, it requires a lot of time to, get back your own personality, your persona. When you've been through a lot of stress, you actually forget the
Absolutely.
person that you have been. So
Yes.
let's talk to Kavita here. Kavita, you are working in the field and you have had a lot of experience. Like Dr. Pri was saying, that not every case, because she was talking about child abuse, that such cases have to be reported, and that is also one of the concerns why so many people will not be willing to come out to mediation, because when she was talking, that hitch of people, I could figure that out, that when you go to the court, you will not speak everything, you know it is left to the lawyers to prove something, and some things are left to be not spoken, and so the truth generally doesn't come out, because the only truth that will be sufficient for winning the case, because there we are winning and losing. Whereas vis-a-vis in mediation, we are handling the issue at the base. So that difference, as she called, it's almost like meditation. But do you feel on the practical exposure that such issues do happen, that people will not come because they will have to disclose, they will have to address certain things which they do not want to address and get away with, like you get a decree from the court, that's the end of it. You don't have to go back to those emotions or to those times or address something that hurts you. So do you feel in your practice that such kind of things do happen? What's your opinion?
Yes, in some cases we do find that, because when the parties have been treated very badly, and the harassment is on a higher scale, they wouldn't have gone in. Normally in India, the percentage of people who approach the psychiatrist or psychologist or any other person for an assistance for mental health wellness is lesser
Yes.
compared to other countries. So people try to talk to their family members and find it. But in case their family members are not very happy or very conducive for them to talk to each other, then they keep it to themselves. They don't open up. It becomes harder and harder. The nut is very hard to break. When
Yes.
they come to mediation, when we sit with them, analyze the issues, this hard prone depression or the harassment is the must crack issue that needs to be resolved. So we tell them, right, we give them a little more space for them and tell them, like, you can just talk to me, right? I'm just going to listen to you and just not going to do anything. I'm just going to listen to you. If it feels comfortable for you, then we will proceed. Otherwise, we will just leave it at this stage, and we can just think about the other methods where you can go and find alternative remedy. But coming to that stage itself, it takes a lot of steps. See, Indian communities, people do not open up at the very first stage. It's a close community. We are all very much connected to each other, though we don't see each other or we don't really talk to each other every day, but it's just it's close knitted society. So in this close knitted society, every time they will think like, what if I tell this out now and I meet my uncle or my aunt next time in a wedding or some other place? What will they think about me?
Yes.
What will happen to my image which that has been created? Will I be able to socialize the same way where how I used to pretend before? Bringing my real image, will it be safer for me to live in this society? Will the society accept me? There will be questions like this, hundreds of questions like this. Okay. So the first thing we will tell them is that we are here listening to you, and whatever conversation that happens here is going to be confidential. I'm not going to tell anybody. As soon as I leave this room, I have trained myself to forget it. So I'm not going to remember anything. So it is for you to let it out and be free. So take it for yourself. It is your choice to make yourself happy and live peacefully. So if you want to do it, you can do it. So people first they will be reluctant, and later slowly they will open up, and finally they'll be 100% relieved. Because giving out, the emptying the bucket itself will give them a greater satisfaction. So in that way, they will be very much happier. But it takes a long, long time, and the session might go around 2 hours, 3 hours. But the mediator, as a mediator, normally I break after when there's an emotional or very strict, these kind of stress involved issues. I don't take more than 1.5 hours or 2 hours of that session, because it is tiresome for the person who is talking to us and to the mediator. Because in a human level, we might not have the same patience from the start point to the end point. Our listening capacity might also be reduced by the time. So when you have to self-analyze sitting in that place as a mediator, that whether you're listening completely or showing your empathy correctly, is the party really confident in you? All these aspects you have to evaluate yourself every time. So when you feel it is not right at this point, you should make a break. Take a break, give them some homework, come back again. So in this way, they will be able to do it. But only apprehension for them will be this, that how to save their image or face value when they get back to the community or society. So if you could guarantee them that everything is going to be confidential and it is only for their own safety, they will definitely open up.
Wonderful.
So that will give them a greater satisfaction.
Wonderful, wonderful perspective. And you beautifully brought out two major points here. That first, the emptying of the heart is much necessary, and the confidence that this emptying can happen without affecting their social image. And second, most important point that you brought out, that the mediator has to self-evaluate. Mediator has to be very patient and understanding, and it affects their mental health also, as Dr. Pri was also mentioning, that when you are taking a lot of emotional, uh, especially in family mediations, when you're taking a lot of emotional baggage of other people, it affects your health also. We come to Dr. Indirani and Dr. Sorry, Dr.
Sonal, can I add one more thing on that?
Yes, please. Yes, please.
A word of caution is that after some time, when the parties have a comfort zone, right, they will start empathizing themselves.
Yes.
That will turn to sympathy. They will start creating their own stories of harassment and saying, just to create a validation or a recognition. So we need to understand that and make them stop there. No, this is not what is required. So we are not going to validate anything and give you a credit on it. And the second point I just want to say about is that the court, you said the what is said in court is not truth, right? I'll tell you the what is said in court is also truth.
Also
But
true.
what is the difference is that what truth I want to prove is the truth that is in court.
Yes.
What is the actual happening, the reality is in mediation. That is
Yes.
the difference. Both are true only.
So facts versus evidence, I would
Yeah, that is
rather
also
put
true.
it like that.
That is
facts,
also truth.
yeah,
That is the truth I want to project.
project. Yes.
But here, this is the reality. I cannot project here. It happens here.
it
It
happens.
evolves and it blooms here. So
Yes.
I cannot project here.
So that really is a big difference. So we have 2-3 things here, and let's call Dr. Indirani and Dr. Jyoti. As Dr. Pri also said, and as Kavita also pointed out, that it is a very difficult, emotionally exhausting procedure. So as academicians, your students that you're training, are you telling them about this aspect also, because this means a lot, because this how they are, because it is their health also going to be affected first, their efficiency, and then their health also, because these things in the long run will make a lot of impact on their health and their decision to whether they want to really go as mediators or not, because it seems like a very promising one. But as Dr. Pri also pointed out, Kavita also pointed out, that it is a very exhausting and a very fulfilling also, I would say, but a very difficult process also, because it requires a lot of patience. So let's hear from you. What are the students' perspective on this, and how you are going about?
Yes, ma'am. To begin with, I totally agree with Kavita ma'am basically. Like she said, as a mediator, they have their own roles and responsibilities to be in conducting the mediation process basically. The students have to understand the pressure what they need to take as a mediator, and for that they need to have a proper foundation. When it comes to the mediation process, as ma'am said, we do definitely have 4 stages of mediation. One is the opening, where we'll get to know about the facts. The second one is the separate session. As ma'am said, we talk to the client individually and get their concerns and what they require out of the mediation. And also the third one is the joint session, what we together speak with the both the parties. And the last one is bargaining, where we come to a conclusion and come to a settlement agreement, basically what the parties want. These are the 4 stages of mediation. Now, as mediation, it is nothing but the participative method, basically, where both the parties come together and they require what they want or come to conclusion what they want. Basically, it provides a win-win situation. That's how we call it as. Both parties win and they succeed in getting what they want. Now, students have to understand the roles and responsibility. As Kavita ma'am was saying, it does need a lot of courage to understand the other person's situation, and exclusively when it is the family disputes. They need to know the pain the other party has underwent or the concerns the second party has basically. Only then they'll be able to resolve the disputes. So for that, we do start up with the simulation process, as ma'am Indrani ma'am in the earlier question answered. We do give them the mock problem basically, and they will read the problem, analyze the problem. They will actually identify the provision of law, what has to be dealt in accordance with the law, and also they will come to a conclusion after the procedure, mediation process. When they adopt it, they'll also come to a conclusion where they think that out of court settlement is also possible in certain issues, in certain matters basically, where they come to a compromise and they also get what they want. So to know that, students have to be trained properly. That's the reason we give them mock problem, where they will analyze what should be the provision of law and what should be the provision of fact and what conclusion should be there, and where they can go ahead not from a regular court proceeding. We can also come to a compromise through the ADR method, basically. So we will also send them to the visits, basically, even to the arbitration centers or conciliation proceedings, and also go ahead and taking permissions with the mediation centers where they see the practicality of it. Like ma'am was telling, the mediator has to have that confidentiality, not to disclose the facts, and to they need to have a technique to handle the clients also. Sometimes when we have seen it practically also, sometimes when the clients come together, forefront to each other, when they have disputes, they start up and quarrel, or they start up the fight there actually. So it is very difficult for the mediators to control them. Like ma'am said, it's very good. I think to give break and to control them, it will be very easy at that scenario. All this they will only learn. The students will learn only when they see it and they have a foundation, very great foundation.
First-hand information is very much important for a child. So the grooming of the child starts from the college, wherein they are allowed to analyze cases. Small snippets are given to them to just think over it and give their answers as to how they can project or protect the parties involved. And what could they be the thought process that goes into it. See to what extent whether A or B would be likely to be affected into it. So they need to sit on that. Other than that, they also try to have a discussion in the class wherein they can think about it, speak out each facet as to how it would affect a person if they themselves were in that particular position. So once they finish the discussion part, we also involve them in the paralegal work. Like from the Legal Services Authority, we are asked to go to the meager section of the society, like going to the slums, to the schools and other areas where they reach out with small problems. And when they come and talk to them, that they have that patience to listen to them, do they empathize with them or do they sympathize with them? Then they have to write a report on the thought process of what they have seen, heard, and understood. This would, inculcate a process of thinking into them to be better persons. And then when we give them a stipulation problem, it would be easy for them to analyze and put it on paper. Now, to help support this is the area where they practically see at the mediation center when the mediator is carrying out the activity.
That's great. We have in Australia as well peers mediation in high schools, where we are starting to introduce this for the kids to start to understand at the very young age. That's what I'm saying. This is very important to educate young people. But when the kids are knowing something and sharing with the parents who don't know it, they are not listening what the kids want to share with them. Therefore, it's very important to educate both of them. And as I said, for the community, we should be the speakers. We should start to speak up about the importance of mediation, about the stages of mediation. In Australia, mediation is regulated now. Family dispute resolution practice is regulated. The parents who are in conflict, they cannot obtain the parenting order without going for mediation first. And when they are not successful, we are producing certificate 60I, it's called, which is showing whether the parents, they show a genuine effort to attend this mediation. For this could be taken into account by a judge. And if the parent didn't want to attend, although could, and this will be the first step for resolution, the cost of the litigation could be imposed on this unwilling party. We are having similar, we are having intake, the introductory step in mediation, when we are talking and we are assessing the parties' capability to attend mediation, that we are looking at the person mental capacity, we are looking as well the level of violence, what is happening, whether this is apprehended violence order was issued, what this order is saying. We are looking at the orders. We cannot provide mediation if parenting order was made before 12 months, if there was previously, but we can, parents can always adjust the parenting order through mediation if the new issues are coming, because children are growing up, their needs are as well growing with them, and this requires adjustment. We are having as well the stage where a mediator is making the opening statement, parties are making opening statements, and from that is created an agenda, which I called a GPS system through mediation. And we are having time when the parties can talk with each other, the exploration stage. We are allowing the parties to talk about their past, but because the mediation is a future-focused process, we are redirecting them for the solutions about these issues. That we are asking them now, what solutions do you see for that? And then we are taking the parties for the private sessions, which are as well strictly confidential. Nothing is going to be passed to another party or to anyone else. And confidentiality is as well extended for the circle of intimacy of the person. That means the friends, the lawyers, family. They know that they cannot pass this anywhere, not publish online anything, which is very important. And then we are inviting as well for negotiation, which is not a battle who is going to be best, but really it is a round table where we are, brainstorming to make the solutions that are going to be best for our kids, because the best interest of the child is a primary to the interest of the parents. And we are constantly focusing parents on their children, how the children are going to think. We have as well a process which is called child inclusive process that parents can choose to take. But because this is as well not follow-up process after that, we don't know whether the parents who agree to this process, whether they are still, respecting what they heard from the child, or they are in any way punishing the child for speaking up. Yeah. And although the child is not present in the room and is with the child expert who is, talking to the child according to the child age, and the child cannot be older than 5, younger than 5, and presenting later on to the parents the opinions of the child about the issue or the impact this has on the child, what the child wants really. Is not presenting verbatim word to word, but is telling generally, showing the pictures the child made. We are having called the bear cards, which the bear is showing the bear is sad or bear is happy, and the parents can understand the child's emotions. And the last stage is the same, the agreement, which is drafted to accommodate the parties' needs and the children's needs. And we are always asking whether they want to revisit them, when they want to revisit them. We are always asking as well whether this solves your problems, whether you are satisfied with this, what is written, because we want them to commit to this, what is going to be put on the paper. We are always explaining as well that it's not a binding process because this is goodwill agreement. And we are explaining the next stages when they can make this agreement turn into a binding one if they want, which is, for example, consent order that they can create from that through creating a parenting plan, because this goodwill agreement could be turned into a contractual agreement, which is a parenting plan when it's dated and signed by the parties and presented to the court together with the form for application for parenting order, for consent order. And yeah, this gives the parents the feeling that they, although there's not a binding agreement, they can make this binding agreement. And whenever they want, but that's where we want them to own the process. We want to own the agreement. This is I am taking proud of that. And therefore I am going to respect what I said in this agreement.
Yes. So there comes a freedom of first the process itself coming to mediation, then the process of making an agreement whether they want it right now to be a binding one or not. When we talk about India, Kavita here, when we talk about India, do we also realize that when she was saying that there are rules now there in Australia that you have to go through mandatorily through a mediation process. So now as our laws are also realizing the importance of it, is it helping us to direct the cases or pre litigation cases also are coming to mediation and they are being resolved, and what is the execution of it, because this is very important for a common person that execution is the process that we do a lot of work out there in mediation. The agreement is drafted and it is a binding agreement because it is by the consent of both the parties, but what is the execution of it, because that will be important for a common person to know.
Yeah. First, I'll take about the initiation of the mediation process.
Yeah.
Okay. After the amendment of the CPC Section 89, it has become mandatory that in case the judge feels that there is an element of settlement, they can refer the matter to any one of the 5 modes of alternative dispute resolution. See, when it is referred to mediation, the judge sends the referral note to the mediation center and the mediator is appointed. And the second part is that this in family courts and special courts, right? In family courts, the Family Court Act itself has a section saying that before taking trial, the court has to involve itself to amicably resolve the dispute among the spouses. This is because the family is the basic element of the society. So we need to keep that intact to keep the society intact. So that was the basic purpose of having it there. So at this stage, initially they were sending all the parties when they filed the case, they were saying when both the parties are present, they will send them for a counseling and or they will send them for a conciliation. That was the earlier process. Now, after the mediations have tested and proved, so for the 15 years now, so people have started accepting it even before going to counseling or choosing any other conciliation method. The court itself is posting the matter for directly for mediation, right? And even the parties, even before the court could say, the parties are saying like I would like to go for mediation, then take up this. This is another case. And there is a peculiar instance in Kerala. Kerala High Courts, they have also have a different setup. When one person files a suit for divorce or restitution or any family matter, the notice is not sent for the case. They send a notice of mediation to the other party saying that this person has preferred a suit or a OP, but you are called for mediation to see if this is resolved, dispute is resolved. And if it is not resolved, then you can take up the litigation. So this mediation notice reaches them first. This is a very good initiative, and it is really successful, right? And here what happens is that the parties do not get the petition copy. So they don't get this petition copy. The petition copy is the greatest havoc that can be done. It's a compilation of everybody's imagination. The small thing which would have been made to appear very, very disastrous.
Yes.
Okay. A friend of mine used to say, like, if I could quote, right? So she had a client coming to her and saying, like, she had faced too much of harassment and she no longer possible for her to live with her husband. So she wanted a divorce. She said, okay, fine, you can come back again. Give me 2 days time. Since you have given all your details, we'll meet after 2 days. I'll draft the petitions and then you can come back again and tell me what needs to be corrected and we can file it on the same day.
Okay.
After 2 days, the girl comes. The lawyer gives the petition to her and asks her to go read it. And after she reads it and she comes back to the lawyer crying, she said, what happened? Did I leave out something or anything? She said, no, ma'am. The only thing is that I never knew I underwent so much harassment until I read this petition.
So that
is the added taste and flavors of the case. Okay, so that adds too much to the problem because party gets the tip of imagination and then everything is added up to it.
Yes.
Okay, so that needs to be checked at the very initial stage. And coming to the next stage about going to mediation, some people are still reluctant to go to mediation.
Yes.
Okay. In those cases, it needs a little push of authority or a judicial will. Only to go to mediation, it is the order of the court. To mediate is not the order of the court. It is a voluntary process.
Yes.
Appearing before the mediator, and once they sit for the 10 minutes or 15 minutes for the opening statement, that is the maximum time that the mediator can use to capture the attention of the parties, build up the trust and rapport, so they gain more confidence. They sit in mediation. Once they sit for the 10 minutes or 15 minutes, after that they will not go.
Yes.
Interestingly, one of my mediation, if I can say, the case was referred from Supreme Court. She wanted a transfer from Madras High Court to Bangalore High Court.
Okay.
Bangalore Family Court. Both the parties were there, the husband and the wife were there. They had a very small baby, less than a year. And I was given this case, and as soon as the lady entered the room, she said, Madam, please send back the court matter to the court. I don't want mediation. I don't want to talk about my life to anybody third person. I don't want to listen to anything. I'm not going to listen to any ideas. She gave me an instruction of a one A4 sheet paper. I said, okay, ma'am, I take your instructions. But I am given instruction by this court. So I need to do my duty. Just give me 10 minutes of your time. Just 10 minutes. After 10 minutes, if you feel that you want to go to court, please do go to court if that can give you the best resolution. She said, okay, fine. Reluctantly, she sat down. I finished my opening statement and she said, ma'am, are you sure you can give me an opportunity to talk to my husband? I said, yes, of course I can. They said, I have never, for the past 2 years, we have never spoken a word. Would you mind this? We talk to him for 10 minutes. Said, okay, that's really great. So can we continue the mediation? I just need a positive word so that I can permit you to sit down here and have a word. She said, yes, yes, ma'am. Then the 10 minutes became 15 minutes, 15 minutes, half an hour became 1 hour. And after 1 hour, the lady became very tired and the baby started crying and the baby needed to be fed. And the girl was, she was also a very young mother, no? So she needed food. The husband became very upset, saying, "Madam, my wife is getting very sick. My child is getting sick. Can I take them out for a lunch and come back again after lunch?" I said, "Of course you can. They are still your wife and daughter. Please
Yes.
take them." So when they went back I just had a break in that mediation, and then they went, had lunch, and came back later in the around 3 o'clock. When they came 3 o'clock, I said, "Ma'am, can we have a chat outside the court, in somewhere in the common place or temple or Marina Beach?" I said, "It's well and good. She is always your wife. You can always have a conversation. So far, you haven't gotten any order of divorce. So no issues. You can go continue your conversation." They did make a conversation, and they came reported to me continuously for 3 days. I didn't do exactly anything, any particular mediation. I just allowed them to talk. Wherever they crossed their limits, I just checked them. I reframed what they were saying. I just placed it in a positive way and made the conversation move smoothly. That's all I did. I didn't do anything more. I was just a fly on the wall, and nothing mattered. And finally, after 3 days, they were united together, and they went back. They said they were very happy. See, uh, this is absolutely their own effort. All they needed was an opportunity to talk to each other directly and talk in a positive way.
Wonderful.
That
Wonderful.
is what is required.
And what actually worked also would, I would say, from your part, you are being humble, but the change of the narrative, as we always call it, that change of the narrative, that makes a lot of difference. Because I've also seen in my practice in family mediation here, once you allow the person to understand the narrative of that person, whether they have heard it correctly, that makes a lot of impact. So as
Yes.
you really pointed out, you really made it so clear. Where there is a lawyer, the narrative would change, but that would change to a drastic level of that. But here
And,
with creator, that yes, please.
and for the implementation part, the thing is, see, when the parties uh, really mutually understand and take a decision, they will abide by it. They don't need even an agreement. Only for the process of court, only for in case the lawyer who accompanies them or the court that refers to it, they want some kind of a conclusion. That is why
Yes,
an agreement is being done.
yes,
And basically, I would say the agreement drafting needs to be more judicial side.
yes,
As in case there is a default, whatever they say, the judge who is taking in the EP court, the execution court, must understand what is the problem and what is the resolution that has been accepted and where is the failure. So the agreement should be that is to be understood for the judge who is going to hear the execution petition, not for the parties who are going to do it by themselves, because they have agreed in principle and they are willingly going to do it. So it is not for them that whether they will do it or not. They have accepted mutually and willingly they have done it.
that
See,
that
if it is forced on them, definitely they are not.
yes.
If it is forced on them, they will not do it. And if it is a part of a failure to do the reality check, say suppose somebody says like they will give 5 crores, okay, it is important that in a private session you need to ask them, it's really very interesting that you are willing to give 5 crores and resolve this issue, but would you let me know how you are going to get this 5 crores? What are the financial positions? If you let me know how are you going to build all this and how the feasibility of it, and who are the person who are going to help you out of this, and how they are going to give confidence in this to make this move roll around. Okay, so if you do that reality check with them and with all the strategic methodology, then they will realize what they said is wrong.
Yes.
Or the same case, the thing, the wife comes and asks, saying, "I need a maintenance or a alimony of 1 crore rupee." That is nowadays common statement. 1 crore rupees. Right? It's wonderful that you have arrived at some amount, but tell me, how did you arrive that amount? Can you tell me how did you arrive at that? You could have asked 10 lakhs, 10 rupees, You could have asked 5 crores, but you have pointed out you wanted only 1 crore. So there must be a reason behind it for arriving at that amount. So we have to understand that people has to know what they are doing. Like then some people, when you ask them this point blank question, they will not be able to think ahead of that. So I give them an example. I tell them when I leave my house, I take a bus to come to court. My bus ticket is 10 rupees. I come to court, I spend the whole day, I take a cup of coffee, and my friend comes and she also takes a coffee, or another friend comes and he also, I'm offering a coffee. So one cup of coffee is 10 rupees. So 3 cup of coffee is 30 rupees. And I go back home in the evening, I need another 10 rupees. So then that's a 10 rupees. So 50 rupees in total, I need to have at least 15 rupees, 50 rupees to come from my home and go back home. So this is a small calculation. So in the similar pattern, can you just think about, go home, work it out. What are the things that you require? First, make a list of what are the things you require and what is the expected expenditure on that, and how far your spouse is capable of giving that expenditure, meeting out that expenditure. Right? Every month I'm earning, you're living with me, then I can manage somehow and give it to you. But I'm going to give the 20 years of the life of money at one installment is very difficult. Yes. I may be earning 50,000 a month, but I may not be able to give 5 crores in a month. Yes. So that is very difficult. So when we take this systematically, parties will understand. Initially, they will also be perturbed and they will also start questioning the mediator. Why are you asking this? The mediator has to be very polite and tell them in a convincing way, saying that I'm trying to walk your path and help you understand what you are trying to achieve. So that when you fall down, somebody must there to tell you at least you have fallen down or help you to stand up and walk again. So that is what I'm trying to tell you. We'll just do this exercise alone, and if you are comfortable, then we can move forward. Then they will start understanding, okay, suppose I have given it in a spurt of a moment. I should have corrected, I should have said two crores. So sometimes people come, sometimes they don't even come. Sometimes there are cases where people have given me a spiral binding of 200 pages of this expenditure in Excel sheets. So there are different people, and some people say like, I don't even want 1 pie. Yes. But they will have 2 children or 3 children. But what will happen to the children? And this lady might not have the financial capacity to maintain the children. So there also we need to have, how are you going to maintain the children? What is the possibility for you? Where will you get the money for them? What is the thing that is, because we don't have the social security system in India. Yes. As we have in Australia or in America or in Europe. Okay, we don't have a social security system. The homes, the so-called children homes, it is very unfortunate to say they don't have the standards for the children to be kept there and to bring them up there. The education quality also is not good. So we can't send suppose a child has had a lifestyle in a posh locality or a mediocre society. Suddenly it is being pushed to live in a home where it is below, much below the standards. It is very much tormenting for the child, and it may not be able to cope up with the situation. It is not going to give a positive image to the society. See, ultimately, the child may not end up being a good citizen. Yes. Okay. Mediation is one of the major value is that to help the society neutralize their parties who come there, their feelings have to be neutralized. I should not think like every person who is wearing a brown shirt or a pink shirt is a bad person. Yes. Because my spouse is wearing that kind. He did the same thing when he was always wearing a black shirt when he did this. So whoever wears a black shirt will be doing this. No, it is coincidence. Okay. So we should neutralize that feeling. Whoever is black, they are very adamant. No. Whoever is fair is always true. No, it cannot be. It's all myth.
Yes.
So we need to neutralize that ideas and that validation, saying that no, it is all situational. In that situation, it has happened like that. That is all. If it had happened in a different situation, you would say it is blame the different situation.
Yes.
So everything changes accordingly.
So that I think two major points that you spoke, Kavita. That first, that there is a understanding between need to understanding between a mediator and a judge also in that aspect. That he's sending, but he also needs to understand what what the mediator's role is. So if we, since our country is evolving in this matter and mediation is becoming, now the law is also coming up, so these points would really make a lot of difference when the judges will be sending. So they will also understand what the mediator has to address, and a clear there a role of communication channel if open between a judge and a mediator. That would also, I think, help a lot. And as you told, the emotional aspect and wonderful like instance you told about that lady and how the family took to that. That was wonderful. And I think what in Dr. Indirani and her team are doing there, when you are teaching those children with the simulation that you're giving them, I think you are giving them the practical exposure of how to adapt. If I say, if in a swimming pool, how to adapt to that. So I am very sure, with that exposure, they are going to be good mediators or problem resolvers for the future. That was really wonderful. So any,
Again,
any closing comments by Dr. Joan? Yeah, yes, Dr. Indra.
it's not easy to again train them so very quickly because again they are children and their background definitely adds on to that. The
Yes,
level of patience, like how Dr. P said, that meditation is what they are doing.
yes,
Here we have to teach them with meditation and yoga to first set right their own mental capacity to think, to channelize them, to
yes,
think from the perspective of the society and from their personal. Because their background is such again varied ones where they come from different types of home background.
yes.
So first they need to understand themselves and then they have to think from the other person's point of view. So it is
Wonderful.
actually a gruesome exercise even for the child to learn and adapt. Of course, from first year, by the time they can come out in the fifth year, to a certain extent, they are molded.
Wonderful.
Yeah,
Wonderful.
this what Kavita said. I think it is very important that validation is this what people are looking in mediation, validation of their feelings and understanding of their pain. And as well normalizing their situation, their conflict, that is not happening only to them, but is happening even in the best of families. That is something what is happening on all possible levels of relationship at work, between the friends, between the family, but between the governments, between the countries. That is something what is absolutely normal, and the validation is incredible tool because required as well empathy. And empathy, validation, and kindness, they are incredible tools which can change person in few minutes. They are starting to be tuned and starting to listen what is said. And another important aspect of this education about each, which Dr. Indirani was saying, talking, is communication.
Wonderful.
The quality of communication and the difference between beneficial and toxic communication. I will read something what I wrote, if you allowed me. One second. I lost this.
No problem.
One moment.
this actually has been a wonderful session because I did not really feel the need to speak because that's what it's supposed
Because
to
we are
be.
talking.
That's really good because I really did not want to. I did not have the need to link because you all are so. And there is Kavita saying from her experience of litigation. Dr. Indrani, you are speaking from the point where teaching those young minds, and Dr. Joanne is from her linguistic and that background. So it's a wonderful team. Please, Doctor.
Yeah, that I wrote, and it was written in one of my meditation about my mediation process. And it came to me, and I wrote that we can use words as a gift or as a thought. Each time we speak, we need to choose whether we want to give or damage. And thank you. And I think that this is very important to teach people, that the words that we are speaking could be a gift to other person. And those gifts, they can cherish and they can build them up again. And we can build ourselves up and we can reconstruct our life. This is going to be, mediation could be a rebirth. It could be a resurrection. Yeah, it is a very powerful process for the families, for the children. It's something what really we should speak up very, very loud about the goodness of mediation. And we ourselves, we should give the compliment because we are the life changers, the peacemakers. And we are, wonderful because of that.
Yes. And it enriches a person's life also because it is
Yeah.
very holistic. What we are doing is a very holistic approach to humanity.
Absolutely.
Makes a lot.
Absolutely. And in India, people are more aware of the circles of life, yeah, that like Shiva, creator and destroyer. We are as well creator and destroyers. We can create what we make kaput. We can rebuild this.
Joanne, when I met you for the first time, I knew your words that time also it really impacted, and today also it was wonderful. Dr. Indrani, your exposure, experience, Kavita's total exposure to it's a good team to today's session. It really there's no need for me to speak anything now. Seriously, it was wonderful. And we have surpassed 1 hour, so I'm sure the recording it has to be limited so that people are interested because people will really forget their own lives when they'll be watching this. So I'm really glad that all of you could take your time out and we all could land up here and meet and talk. And Kavita was traveling, and it's a pleasure that you could join us, Dr. Indrani, from your time from your office. And we really hurried Joanne from her one previous meeting because of the time calculation mistake by
No worries. No worries.
So lovely session. Thank you so much, everyone.
Thank you, Sonal, for giving us this platform.
Thank you.
Thank you.
Thank you. It was very, very interesting.
Thank you.
Lovely.
Thank you so much.
Lovely.
It was a real privilege, ladies, to meet you and to listen to sharing the experience that we have. Yeah, I hope that we are going to have more talk together. I really enjoyed this. Thank you so much for inviting me as well.
I will bring you again also for one more session. And of course, we have to do one session with Kavita as a lead, and we'll bring Joanne also together. And Dr. Indrani, we are going to do one more session with you as your team from your college and with your students also on board. So lovely session. Thank you so much, everyone.
Thank you. Have a beautiful